Most criminal cases in Massachusetts are resolved through a plea. This is when the defendant essentially admits to some or all of the crimes that he's charged with. And in exchange for the admission, he gets a more lenient punishment. Now, it's always best if you can work out a plea deal or a plea agreement with the prosecutor before going in front of the judge and tendering the plea. Defendants often become very stressed and very frustrated with the prosecutor as the two sides are trying to work out a plea agreement. And I think a lot of this stress and a lot of the frustration comes from a defendant's unwillingness or simple inability to see things from the prosecutor's side. So I think if you just try to step back, I know it's hard to do, and look at things objectively and try and understand where the prosecutor is coming from, it might be less stressful, less frustrating for you if you're a defendant. So first of all, the prosecutor, his number one goal is to keep his job, all right? And he's not going to do anything unreasonable or risky or anything at all that might get him in trouble with his supervisors or might ultimately result in him losing his job, all right? So he's not just going to dismiss your case in its entirety at the first pretrial hearing if he thinks that that's going to get him into hot water. All right, and he's not going to drop certain charges if, again, that's going to raise eyebrows with his supervisors and his superiors. Right? So the plea needs to be reasonable, and he needs to be able to explain that plea if he's called on the carpet and forced to justify his actions. Number two, the prosecutor has to essentially advocate for the alleged victim. The alleged victim has rights in Massachusetts. They have to be informed. They have to know of hearings. They have the right to be heard during a plea argument. And prosecutors take this very seriously. And if the alleged victim has input or wants certain conditions imposed, then the prosecutor is obligated, in most cases, if those requests are reasonable, to push for what the alleged victim wants. So if you, say, have an assault and battery, say hypothetically a husband was drunk and he hit his wife, and the wife wants probation with screens for alcohol, no alcohol with screens, the prosecutor almost 100% of the time is going to ask for that condition as part of probation. And then last, the prosecutor, when he's trying to hash out a plea, wants to avoid trial. Right? The prosecutor essentially has to avoid trial for most of his cases. If you go to district court, and I'm sure it's the same in superior court, you will hear everybody tell you how busy they are, probation, the clerks, and so forth. The prosecutor is by far the busiest person in the courtroom. The prosecutor every year has hundreds of cases, and it's simply impossible for the prosecutor to take all of his cases to trial. So he has to give reasonable plea offers. And what I find is most prosecutors will give a plea offer that any reasonable, culpable person would accept in lieu of going to trial. And if the defendant rejects that offer and the case goes to trial, then really it's on the defendant at that point. The prosecutor will say to the judge, I offered X, Y, and Z, it was totally fair and reasonable, and it got rejected. Right? And he'll put the burden basically on the defendant for the reason why the case is now in trial. I've written a blog post on this, and I'll put it in the description below.